welcome to Sahara TV, and with us today is Nnamdi Kanu, international spokesperson and attorney. Um, are you still there, Bruce?
Yes, I'm here. I can
Oh,
hear you
great.
well.
Oh, great. Oh, great. We just want to be sure you're there. So once again, welcome to Sahara TV, and with us in the studio on the Zoom uh, interview segment today, we have Bruce Fein. That's the international spokesperson for Mazi Nnamdi Kanu. He's also the international attorney. It's a pleasure having you on Sahara TV again, please.
Well, thank you for inviting me.
We're looking at the preview of the Mazi Nnamdi Kanu's trial. With us to look at this issue is Bruce Fein. He's international spokesperson and he's also the international attorney, counselor, so to say. It's a pleasure having you on Sahara TV, sir.
Well, thank you for inviting me.
The trial has been described as a farcical trial, a charade of monumental dimension that involved a litany of human rights violations. Bruce Fein, how will you describe Mazi Nnamdi Kanu's trial by the Nigerian government?
Before I give a one-word description, let me give a little bit of background for the audience so they can make their own evaluation rather than just based upon my opinion. Last June, while Nnamdi was visiting Kenya, he was kidnapped, tortured for many days, and subject to what's called extraordinary rendition to Abuja. We don't know all of the details because the federal government has been very reticent to disclose exactly what was done in collusion with the Kenyan authorities or with Kenyan bandits, if you will, to kidnap and torture and extraordinarily rendition Nnamdi to Abuja. But whatever the details, it surely did not comply with international law requirements for extradition, which entitles a detainee to notice an opportunity to challenge the legality of any kind of detention and prosecution, which clearly did not happen in this case. This was last June, so approaching now 6 months. Now, since that initial arrest and charges, there has not been a crumb of evidence introduced to substantiate any of the alleged so-called terrorism-relating charges against Nnamdi Kanu. The vast majority relate to broadcasts from London in UK on Radio Biafra. They were not broadcast from Nigeria. And the Nigerian Federal Criminal Code is relatively clear that for alleged crimes that occur outside of Nigeria, there's no jurisdiction to adjudicate those crimes in Nigeria itself, among other things. But this is last June. Now, since that time, there have been a couple of hearings held in which Nnamdi's lead counsel, Fein and with assistance, has filed a motion to dismiss all of the charges based on the theory that they don't allege actual violations of criminal law. In fact, some of them allege no more than exercise of free speech and association. Let me give you just one example. Okay. One of the charges is that Nnamdi Kanu professed his adherence to the indigenous people of Biafra, IPOB. IPOB, about 4 years ago, September of 2017, uniquely in the whole world, was proscribed as a terrorist organization in an ex parte proceeding. Ex parte means IPOB was not given notice. The Attorney General went into court and said, President Buhari has told me that IPOB is a terrorist organization, and so you need to proscribe it. And that was the beginning and end of the case. Now, despite lobbying by the Nigerian government, well-funded, to have other countries list IPOB as a terrorist organization, it has uniformly failed. This is 173 other countries. And indeed, there have been 5 human rights experts from the Human Rights Council of the United Nations that sits in Geneva, who wrote a letter to President Buhari in late 2020, stating they had examined the case against IPOB and were very concerned that there was no due process, that Nigeria seemed to treat the mere search for an independent sovereignty through a referendum by peaceful means was a terrorist act. And these human rights experts said, no, that's protected freedom of association. And indeed, these 5 experts asked President Buhari, you need to reconsider whether IPOB is a terrorist organization, because your process seemed to have violated norms of international law. They asked President Buhari within 60 days to provide what evidence and what process was utilized to demonstrate that IPOB was a proscribed terrorist organization. That's 60 days. Now, that's over a year has elapsed since that request. And President Buhari, Nigeria, has come up with nothing, zero, to justify the listing. And mere membership in IPOB under the current Nigerian system is a crime. It's a terrorism crime, even though the mission of IPOB is to secure an independence through peaceful means, referendum. This is speech and association protected by the International Covenant on Civil and Political Rights, and it's protected under the Nigerian Constitution if it was honestly honored. Well, that's just one example, I believe, of the kind of charges that are leveled against Nnamdi Kanu. Now, there has been a motion to dismiss all of the charges based upon the flaws in the pleading and the evidence. Additionally, one of the very most prominent sons throughout Nigeria, Femi Falana, has maintained quite persuasively that given the allegations of where the crimes occurred, the federal government has no authority to prosecute. These are within state jurisdictions, and no state attorney general, no state authority has filed any charges against Nnamdi Kanu. There was a hearing scheduled last November 10th to decide and address the issues that are presented in the motion to dismiss. But they were canceled, postponed in part because the government, again, in violation of international law, refused me access to the courtroom. I had not engaged in any disruptive activity. I'm one of Nnamdi Kanu's counsel of choice. And international law, including, again, the Nigerian Constitution, protects the defendant's right to have counsel of his choice. And at that hearing, there was a postponement, an adjournment, if you will, to January 18th. And that's the current schedule for hearing the motion. So January 18th is not the trial date. It's not to entertain evidence and witnesses that would purport to show some kind of criminality on Mr. Kanu's part. It's simply to decide whether there's anything sufficient, even in these threadbare allegations, that justify going to trial.
You also took a swipe at the judge, and you actually pointed out the fact that the judge is not immune from criminal prosecution. And Justice Binta Yaku, he's been working in collusion with the DSS and the FG to punish MNK as a political prisoner. Could you expatiate on that?
Yes. First of all, you are absolutely correct that under international law, criminal law, judges are not immune if they become participants in what is a clear travesty of justice. As an example, there were multiple Nazi judges who enforced Adolf Hitler's Nuremberg laws that were flagrantly discriminatory and illegitimately applied to Jews. And they were prosecuted after World War II for crimes against humanity. And the International Criminal Court has jurisdiction over individuals acting under color of foreign law, including judges, who then lend themselves to complicity in crimes against humanity. And one of the ways in which you can do that is to disguise what is no more than a trumped up kangaroo court as somehow due process. And the judge clearly is vulnerable to investigation and prosecution if the evidence is forthcoming showing that she's working hand in hand with DSS, as opposed to doing what a judge is supposed to do: act impartially, act independently, act based solely on the judgment of someone learned in the law, in examining allegations, the facts, and the law, and coming to a conclusion on that basis. Now, what the law requires in circumstances where a judge does not feel in good faith that they can execute the demands required, and that for fear or otherwise, we don't know what kinds of threats or implied threats have been communicated to the judge. If she lets Nnamdi Kanu under the law free, what kind of retaliation there might be. But if there is that fear of retaliation and it's impossible to make a judgment on the merits, then the law requires resignation and moving so there's not direct complicity in this violation of human rights.
But shouldn't the judge be, required to recuse herself even at this point in time, based on this, the fact that she's been indicted in these instances?
It's certainly true that I practiced many times in U.S. courts. The standard for recusal is if there's an impression, even an appearance of an inability to act impartially. And I think that's been amply demonstrated in the way this case has been handled from the outset. We have to remember that every day that elapses is another day where Nnamdi Kanu is being illegally detained. Again, we have detention beginning in late June. There still has been no hearing that requires the government to show evidence of criminality, not at all. So we have a situation where the judge is permitting punishment sentence before the trial, which sounds like a page out of Alice in Wonderland, and shows how, I think, far and how irregular these proceedings are. And I would agree with the observation that the way in which the process has been handled would indicate the judge needs to recuse herself, stand aside, because no longer is there appearance of impartiality. There have been ex parte communications with the prosecution alone, and that's simply on its face showing prejudice against the defendant.
You had also said that you'll be pursuing all international and diplomatic platforms to see that justice is done and all fundamental norms of laws are complied with as regards as far as this trial is concerned. You mentioned the fact that you'll be taking the case up to the international courts, the International Working Group on the Arbitrary Detention, as well as the International Criminal Courts, the International Court of Justice that's in The Hague, as well as the U.S. Congress. How could you give us an update on what has been achieved so far?
Yeah. So we know that the Working Group on Arbitrary Detention, and I've made multiple submissions, is actively considering the case. Now, obviously, it would be wrong for them to share views on one side rather than the other before there's an opportunity for the government of Nigeria to respond. But I know it is under active consideration. The working group meets 3 times a year, and I will be alerted if the government of Nigeria disputes any of the submissions that have been made. Now, what is the consequence? The authority of the working group is to identify detainees who are being held in violation of international law. Since the working group, as you can imagine, does not have armed forces, it doesn't have police force to enforce its judgments, it does have, under international law, binding authority that needs to be respected by other countries and judiciaries, or risk sanctions. So that's what an opinion out of the working group that finds Nnamdi Kanu is being held illegally would have, we believe, strong influence not only within Nigeria, but in other countries that might be considering sanctions for holding Nnamdi Kanu in violation of international law. Just as an example, and although the cases are not parallel, you remember when Umaru years ago, about 10 years ago, was attempted to be extraordinarily renditioned to Nigeria in a crate because he allegedly had stolen funds. He was not a character who had, unspoiled reputation. And when the British authorities discovered this attempted kidnapping, extraordinary rendition, they not only caused his release, but in addition, they broke relations with Nigeria for 2 years. So that's the kind of international sanctions that may ensue if the Nigerian government did not comply with a ruling of the working group of the Human Rights Council. The other cases that are more, they are on a slower track because the requirements of the law are a little more arduous. We're really following the path of the Gambia in the International Court of Justice, sued Myanmar for genocide against Rohingya. This is in 2020 and got an initial ruling. But there are many elements of diplomacy involved in one country deciding to sue another for genocide, but that's in track, and we believe that the working group decision should propel that in an accelerated fashion.
Now, I'd like to get your perspective on the U.S. government's stance as far as this issue is concerned. We know that when the Democrats have been passionate about Nigeria, especially during the Obama administration, and we know that at some point in time, Joe Biden then, as well as Hillary Clinton, spoke out against some of the human rights violations in the country. But recently, some couple of months back, the U.S. Secretary of State Anthony Blinken visited the country, but there was no strong indication that he strongly pushed against these human rights violations, as well as the flagrant disregards of violations with regards to the rule of law in this country. So what's going on there? Is America no longer interested in human rights and the rule of law as far as their foreign policy is concerned with regards to Nigeria?
I don't know whether I could concur with all the rigor of the statement. The United States, like other countries, acts for its own national interest. It's not, an altruistic institution. We still haven't taken any measures of seriousness against Saudi Arabia for assassinating one of our journalists, Jamal Khashoggi. We feel our oil interests or selling weapons to Saudi Arabia is too important. Now, what's going on in Nigeria? I don't know what's going on in the inner circles of the administration. I think that historically in Africa, the United States has often deferred to Great Britain with regard to former colonies. And unfortunately, that's another angle that I'm actively pursuing. The United Kingdom, for really, in my view, and inexplicable reasons, has not really voiced defense of Nnamdi Kanu, even though he's a citizen of the UK, and the extraordinary rendition was against a UK citizen. And why that UK reticence, it's not clear to me. I hope to meet with the Foreign Secretary and clear that up. But I think it's premature to say that the United States has kind of written off Nigeria as a failed state as long as they at least purport to attack terrorism and sell us oil. Who cares? Even though, and one, I think, earmark of that is the rather controversial sale and delivery of these A-29 Super Tucano aircraft. You know that the United States has not given Nigeria free rein over deploying their use, insisting they be deployed only in the Northeast and Northwest. It's just not where Biafra is. And we think that's because the administration doesn't trust the Nigerian government to use it, against so-called terrorist groups. And that's why the supervision persists. So I think that we have a situation where The Biden administration doesn't really have a complete, game plan. It's obviously doesn't have the highest priority of human rights on the agenda. I don't think any country does that. Countries are not philanthropic institutions. We don't want to be too cynical, but we need to recognize that as we move forward and try to make it clear, I believe, to the American government that they would benefit from a peaceful and viable separate sovereignty for Biafra in defeating radical Islamic terrorism and promoting international peace and security in the region.
Now, finally, the Nigeria's Attorney General of the Federation and Minister of Justice, Abubakar Malami, said that President Muhammadu Buhari will consider the interests of Nigeria in the case to release Nnamdi Kanu. What's your view about this political option?
It would be wonderful if he did that. After all, it wouldn't be unprecedented. The president of South Africa released Nelson Mandela and negotiated a dismantling of apartheid. So maybe Mr. Buhari would like to follow that path. I, however, am suspicious of the authenticity of that representation by Mr. Buhari. You would think would be accompanied by at least a stand down in the southeast, where the ongoing massacres and genocide of Biafrans persist without any rescission. Moreover, you may recall after my last visit, the Attorney General Malami made a public statement that they were willing to sit down and negotiate with Nnamdi Kanu, but they were waiting for some kind of response, indicating in the same tone as President Buhari, well, we should talk this out and see whether we can't get a consensus. Let's not resort to violence. In the aftermath of his representation, I wrote a letter to the Attorney General Malami. There was nothing top secret in it. It simply said very respectfully, if you have an interest, let's meet and discuss the protocols for discussions. What would the venue be? Would they be confidential? Would there be any preconditions? What would Nnamdi Kanu's status be? Released out of solitary confinement? Who would be representing the government? Who would be representing Nnamdi Kanu? Anyway, it was simply procedural mechanisms to try to facilitate a movement forward to find what everybody hopes can be a peaceful way for the people of Nigeria to resolve the differences, really, which were accentuated by a century of very cynical British rule. Maybe not a complete century, but close to it. But there was no response, no indication of any interest, and even flirting with that idea. So that casts into doubt, I believe, the sincerity of President Buhari's statement. But listen, if he moves forward on that front, all to the better. He doesn't really have any barriers, since it's within his unilateral control to stop the ongoing massacres and genocide and crimes against humanity in the Southeast.
Mr. Bruce, thank you very much for your time.
Thank you so much for having me.